Okay, I do have a fairly low voice. I want to welcome everybody to our Sunshine Week seminar. First off, I want to thank Belleville High School for making the facility available to us. I'd also like to thank the organizers, particularly Linda Baum, who sits on our board. We have another board member here, Ron Miskoff. Here we go. And our panelists, of course. I will introduce them in a minute or so. I guess when I always start these my talks with factoids. The first nationwide Sunshine Week began in 2005 and occurs each year in mid-March, coinciding with James Madison's birthday, which is on March 16th, the father of our Constitution, and National Freedom of Information Day on March 16th also. As Supreme Court Justice Louis Brandeis said in 1913, sunlight is said to be the best of disinfectants. While some think that this statement is overused, it can't be stated enough. It serves as New Jersey FOG's core principle. The New Jersey Foundation for Open Government is the only organization in the state that's dedicated solely to improving public access to governmental records and meetings. We work to educate the public about OPRA and OPMA, or the Open Public Meetings Act, as well as increase governmental compliance, transparency, and accountability. We were established in 2001, and Mr. Miskoff is one of the original founders, and we're very pleased about that, to have him.
Well, Fran, thank you very much for that wonderful introduction. Just very briefly, a little bit more about me. I think that about 85 to 90% of my practice deals with the Old Public Records Act and the Old Public Meetings Act, and most of that is litigation. So I handle litigation throughout the state, almost all of it for OPRA.
As an elected official, I have an obligation under the board, under the Ethics Commission for the Board of Education, to just tell you that I am speaking on my own behalf. I do not represent the Monroe Township Board of Education this evening. I'm speaking as a citizen with my own opinion. So none of my statements are a reflection of the total Board of Education. And that's one of the rules, and I do want to play by them. So I will be happy to answer questions regarding, general questions regarding Board of Education and my experience, but I am only speaking on my own behalf, and I do not represent the opinions of the board, because that's the full board, and I cannot speak for that. So thank you. I'm sorry about that announcement.
So one of the things that we like to do at these seminars is we try to be responsive to what your concerns are, because we could probably speak for a very long time about the Open Public Records Act, the Open Public Meetings Act, but our experience has been that when people come to events like this, they have certain specific areas that they want to know about. So at the outset, I wanted to give anyone the opportunity, if they wanted to just raise any questions, but also as we give our talk, if you have questions, just raise your hand and we'll recognize you. We're happy to take your questions as we go along rather than at the end, because I find that it makes for a better seminar.
Accounts, watchdog, gadfly, and I'm proud of it. I have a question that I noticed today on tonight's City Council meeting. I have one question on the City Council and one on the board meeting. Tonight, this was listed under confidential items, and I'll read to you exactly the way it's written on the agenda. 2015 street improvements. City engineer presents project status and proposed scope modification for discussion. Confidential item number 1. I can tell you the 2015 road resurfacing project was awarded to the contractor last year to Smith Sunday, and it was also bonded for last year. So according to the law, I know that any contract modification can only be up to 20%. I 5 years, any change order we have is always discussed in public, never in private.
Okay, so what Mary's talking about, and it's an excellent question, what Mary's talking about is what issues can a public agency discuss in closed session versus open session. So every public agency is subject to the Meetings Act, the Open Public Meetings Act, OPMA. A lot of times folks call it the Sunshine Law, even though it's in New Jersey, it's not called, that's not its name, but colloquially you'll hear Sunshine Law. So every public agency, when it meets, it has to do so pursuant to notice, and it has to have a public meeting. It means the beginning of the meeting has to be open to the public. And if they want to discuss certain items in executive session, they have to make a motion, they have to say what items they're going to discuss in executive session, and then they can exclude the public. So what Mary's talking about is the Meetings Act doesn't allow the public agency to discuss whatever it wants to in closed session. There's a specific list, there's a limited list of items that public agencies can discuss in executive session. Michelle, what are some of the things that public agencies are allowed to discuss in closed session?
Let me talk about the exceptions. In your packets, everybody has a copy or should have a copy of the Open Public Meetings Act. And on page 508, it tells you the exceptions. So there's two ways to look at it. There's one with a small booklet, that's a reference, and the other one is on the right-hand side of your folder is the Open Public Meetings Act. Those are the exceptions, and very often municipal government agencies do not hold to those exceptions. And it's been my experience that when we know what the exceptions are, as a member of the public, we can keep the government agencies really, will give them a standard that they have to uphold. Because, and that's one of the best things about open government and transparency that we have come to advocate for, because the public knowing what to do is really important, and to say what they can go in for certain contracts. Actually, Walter, I don't know exactly. I know the exceptions.
It could be a personnel issue if they're having problems with the contractor,
Right.
they wouldn't be allowed to discuss that. It's all a guessing game. I mean, what I would do in my experience is I make sure I keep an eye when they approve the executive session minutes, and then I open them so I can see what was discussed. And they can't take any actionable, they can't act on anything in closed session. They would have to then put whatever if they wanted to fire the vendor or increase their pay, they would then have to put it on regular, so.
There's confidential information. There is a matter, and this is in your pamphlet, any matter that the information would impair the right to receive funds from the government of the United States, collective bargaining agreements until they are approved, and very often just some personal information if it's an employee or like especially a student in our case on the board. Those are confidential. And you're allowed to go into closed session for that. But again, it's very limited, and there are very few things. But I would think what Mary's talking about is not one of them.
Yeah, I mean, it's very interesting. Tina mentioned the minutes. One of the things you should always get are the executive session meeting minutes and the resolutions that authorize the executive sessions, because you can see you should be able to see what they're discussing in executive session, who they're meeting with. And one of the big things to look for is who exactly are they meeting with? Because when Mary said, well, they're bringing in the engineer to talk about X, Y, and Z, to me that's a bit of a red flag, without commenting on your specific situation. Because if an attorney is meeting with the board in executive session, there's a very high likelihood that attorney is giving legal advice, and that's a permitted use of executive session for for the board to ask questions of the attorney and for the attorney to provide legal advice. That's very appropriate. However, there's really nothing that an engineer can do that's privileged. I can't think of anything. So when I see executive session meeting with engineer, well, there's really nothing an engineer can say that disclosure would harm the public interest. So that's a bit of a red flag.
And it's up to you to pursue it, because that's when they have their general conversations.
Well, let me ask my fellow panelists a question. Do you think that if a body is going to discuss pending litigation, which is a legitimate exception, should they be identifying the name of the case that they're going to discuss in the resolution authorizing the closed session?
Well, you know better than me, but I believe if it's litigation that's been filed, then they have to reference it in the resolution before they go into executive session.
But if I threaten to sue you, that's just pending litigation.
Right.
Rory's going to sue you, maybe. And if you wanted to discuss it with your attorney, it's perfectly legal. But they use that's used as a tool to say, okay, we want to have a meeting about something we don't want open, we don't want to sunshine. So they'll use pending litigation, because I have one right now for that precise reason. But I think there's a 90-day limit on it. They have to release it. There is no litigation.
Well, the rule. I see. The rule is that the executive session meeting minutes must be prepared and disclosed within the exact term is escaping me, promptly. The law says promptly. So what does that mean in terms of the reality? It means 30 to 60 days. However, with respect to executive session minutes, they can redact those portions of matters that are still active. And there's also a school of thought that says when you're dealing with personnel issues, medical issues, student issues, attorney-client privilege, there's a school of thought that says those privileges last forever. I've had mixed success in chipping away at access to minutes about closed matters. I agree with you that if a matter is closed, the interest in non-disclosure goes down, and the cases say that, but the interest in non-disclosure doesn't become zero. So for an active case, very unlikely you're going to get anything about an active case. So be careful not to confuse the obligation to create the minutes, 30 to 60 days, versus the obligation to disclose, which is really, it's a very fact-sensitive question. Penny.
Can I just answer that? I'm sorry. One of the things I do while I watch this particular governing body, I do things routinely on a monthly basis, and I request all lawsuits filed against them.
Yeah, I just did
The
that.
verbiage is escaping me right now. But I also ask for tort claims. So that's pending litigation. If somebody files a tort, it'll come up in there. It's a game. You really have to learn the tricks of it. And it's not, they don't make it easy.
To the nomenclature of the law, the word that they actually use is potential litigation. We are going in to discuss potential litigation, which could you describe from a legal nomenclature standpoint the distinction between potential litigation and pending litigation, if there is one?
Well, sure. I mean, potential litigation is a lawsuit that's been threatened, or where I think the public agency reasonably knows or should know that there might be a lawsuit. Right. Now, once you have an actual lawsuit, then that brings a lot of other exemptions into play. So you could, discussion about a lawsuit could fall under the deliberative process exemption. It could almost certainly would fall under the attorney-client privilege. And if they're discussing a settlement, well, a settlement agreement is a contract, so that would fall into contractual negotiation. Technically, it would fall into contractual negotiations. So I think that the grounds for for going into closed session, once you have an actual lawsuit, they have several grounds. And I mean,
So can they just have a blanket statement, potential litigation, and not have to disclose what the potential litigation is concerning?
Now, what I think Penny is referring to is the motion or resolution to authorize the executive session.
Yes.
And oftentimes you do see potential litigation. I don't think that that's sufficient. Now, there are circumstances where I think if the potential litigation is public agency versus someone, I think then it would be in the interest of the public agency to not reveal who they think they're going to sue, because maybe that would harm the interest of the public agency. But oftentimes it's the other way around. I think if a public agency receives a notice of tort claim, then it would be pending litigation, Jones versus public agency. I think then that they should disclose. A lot don't. And the problem is, your remedy is, well, you write a letter, or you say, well, hey, pending litigation, what case is that, or what potential case is that? And then if they continue to refuse to disclose, then the remedy is to sue them under the Meetings Act, which is, that's too much stake, because it's suing them. It's not like the Records Act, where you can go to GRC, you can file for free. Under the Meetings Act, you have to do a lawsuit. So it's $250. It's a lot of paper. It's going to court. It's much more difficult process. And that's one of the problems that's part of the dichotomy between the Records Act and the Meetings Act. The Records Act, it's much easier to try and enforce it. The Meetings Act is relatively much higher burdens trying to enforce. So that's why you get situations where people can get away with for years pending litigation.
Potentially.
To that point, as someone who goes to a lot of municipal meetings, even before I was an elected official, if I saw that on a frequent basis, that would be sort of their way of saying, we're not really telling you what we're going to closed session for. That would raise suspicions on my part, and I would constantly be asking what that litigation is. And what happens is, even if in the beginning it seems like they're not answering that question, they're not doing it, ultimately, if you start to talk about the Open Public Meeting Acts require certain things, if you do a little research, that closed sessions are supposed to have a resolution, a proper resolution, they start to get the idea that you know what you're talking about, and there starts to be compliance. Just an example, it's not about closed session, but when I go to our municipal meetings and they see resolutions on there, they used to just put a resolution by title. They still don't put the value of the resolutions, but they are putting now the statutes, and they're also putting the lawsuits. So we're getting, it takes a long time, it's a slow process, but if you go with the information about the Open Public Meetings Act and what the requirements are, there's a slow process, and they tend to come around because
It's been 2 years and it hasn't happened.
Well, then there's a different...
But my question is, so does pending mean that something has been filed?
Yes.
Thank you. That was my answer I was looking for. Potential means not filed. Pending means something has been filed. Thank you.
So it could be a civil suit or a tort claim, and you can go for that. I've also had some success with the Open Public Meetings Act issues, and at least getting them to behave a little better. The county prosecutor is supposed to enforce the Open Public Meetings Act the way the law is written right now. So you can write to the county prosecutor and ask them to intervene. And usually...
Who is that for Essex County?
I don't know, you would contact your prosecutor's office and ask them.
Well, it would be the Essex County Prosecutor's Office.
Yeah.
And look, I mean,
They should have someone assigned to the Open Public Meetings Act. I mean, it's just another thing you could do to sort of, the carrot and the stick, that it is an option. I've had some success in Union County with that. And as far as them at least telling them, you have to do things a certain way, never holding them accountable really, but that they have behaved a little bit better, and they're very politically connected to the county prosecutor's office. So if it works there, I would say it's worth a try.
Yeah,
It's a letter. You write a letter.
Yeah, you write a letter to the county prosecutor, and sometimes it's infrequent, but sometimes the prosecutor's office will write a letter. I've seen them. They will write a letter to the public agency saying, you're violating the law, don't do it again. And I've even seen one letter, this was in Somerset County, where they said, don't do it again. If you do it again, we're going to sue you. And I'm not aware of any lawsuit initiated by a prosecutor under the Meetings Act, but it is something they take seriously. Again, the range of responses goes from nothing all the way to the next time you do it, we'll sue you. So it's something that's absolutely worth your time, because technically, again, unlike OPRA, open Public Meetings Act violations are within the jurisdiction of the county prosecutor.
Okay.
Yes?
Question. My name is Yvonne Balso. I'm from Jersey City. I go to every council meeting, and what I notice is that the mayor gives away, I'll give an example, public land, 99 years for $1 a year. I'm looking it up, and it's an LLC. Where can the public find out who these LLCs are without going crazy?
Current business report, I forget, I mean, I do this all the time, but you order a business status report, and it costs you $6.25. You can do it over the internet, and they'll email it to you and make it available to you right away. And it'll tell you all the names of the officers, the agents who service the process. It won't tell you who the owners are for an LLC. It's one of the reasons why people have LLCs, is because the owners of the LLC aren't recorded. It's just the officers. But even then, you'll see who the president is, and you can get an idea of where they're coming from. So that Secretary of State's website, $6.25 per report.
If there's some kind of legal document, would the owner, the president of the LLC have to sign the agreement?
Well, that's an excellent point. Any agreements, if there's a pilot, if there's a pilot agreement, then yes, an officer, at least an officer of the company, when you hear about all the pilots.
Explain what pilot is, payment
Yeah,
and taxes.
it's a fancy way of doing tax abatement and reducing someone's tax liability for 99 years or whatever. I mean, I guess it's 99 years now.
Well, we do 40 years, 30 years, 40 years constantly.
If that becomes a contract, you should be able to OPRA it through the city. That agreement should be a public document at this point. So if you do an Open Public Records Act for that specific, if you know what land it is or what it is, or you can just say you'd like to have the list of those agreements, those particular agreements in a month's time or a week's time, wherever you think they might have occurred, or a 6-month period of time, you'd like all of those.
We get the same resolution for going into closed session time after time. A meeting, it says land acquisition. The next meeting, it says land acquisition. There's never any detail.
Well, land acquisition is a little tricky. You're getting
distilling it down.
Sure.
I mean, it also says litigation, land acquisition. Now we're in contract negotiations. They list the possible people that they could be negotiating with. But nobody, that's only some part of the time. Nobody ever comes out and says anything. Can they use a boilerplate for going into closed session?
Okay, so the question is, can the public agency use a boilerplate motion or resolution when they're going into closed session? The school boards are particularly bad at this. And the answer is they're not supposed to, but enforcement is rare. I agree with you that a lot of public agencies simply lack meaningful detail in their motions. If they're negotiating with a bargaining unit, they should identify the bargaining unit. What's the big deal? If there's a potential land acquisition, they should identify the parcel unless it would harm the public agency's interest, which it may. If they're in contract negotiations, they should identify the counterparty. If they're in litigation, they should identify the name of the other side, because then, while they're not required to tell you what the lawsuit is about, then you can go make an OPRA request for the complaint. If it's a federal lawsuit, you can go on to the federal court's website and order copies of records, but they make you go through hoops to find out that information. So again, it comes back to the problem we discussed earlier, where they can kind of get away with this vagueness because it's a high burden to file a lawsuit over something like that.
Again, I would write to your county prosecutor's office if it's a habit of theirs. If they have nothing to lose, and, at least them looking into it puts them on notice that someone else is paying
And then,
attention.
in terms of her question, Bloomfield has a monthly newsletter. I OPRA'd the names and the email addresses. I got all of them. I OPRA'd the cat and dog licenses. I got names of people with cat and dog licenses, their addresses, their emails, and then Bloomfield refused to give me the animals' names, saying that the animals' names were confidential. I threatened to sue them, they turned it right around.
It's just weird.
Going back to your question about the closed session resolutions, do they have a public forum after they come out of closed session? When is just very briefly, when does the closed session take place?
If they've actually voted on something, or if they've actually decided on something, most of the time, they come out and vote in public.
Okay, I don't know if everybody heard that. If they've decided on something in the closed session, they will come out and then either read a resolution, and at that time, even if they haven't been specific, I mean, I believe in specificity when you go into resolution, closed session resolutions, but at that time, if they're voting on something, it should be very clear what the vote is about, and then I would, and Walter can correct me, I believe that under the Open Public Meetings Act and Open Public Records Act, you would be entitled to the full information because they've actually acted upon that in public. And you should have all the details of what that land acquisition is. Walter?
Certainly after it's been approved.
Right.
Certainly.